Hot topic in our office today is alimony modification. Lots of people right now, especially people who were used to being the high income earner in their families or with their ex-significant other, are suffering some temporary, possibly permanent setbacks with their income. There have been a few recent cases on when you can modify alimony and some of the things that you would need to be able to prove in order to have that modification. So the case that I wanted to talk to you about today is called Suarez versus Suarez. It's out of the 4th District Court of Appeal in 2019. And that case reiterated what has been longstanding law, that in order to have a modification of your alimony obligation, you must have a substantial, material, involuntary, and permanent factors in order to modify your alimony. In that particular case, the wife had a business, the former wife had a business, and she suffered a 75% loss in her income. That was because she lost a significant client and also because of some market conditions. So she had a loss and she was entitled to a modification of the alimony that she was paying her former spouse. Also in that case, there were findings that if the court has not made a determination as to the retro amount that may be owed, that could be reversible error. So I do want to advise you that if you are suffering right now financially and you have an alimony obligation, don't forget that while it probably is significant, material, and it's definitely involuntary, we have to get to that permanent status in order to have a modification. The way to fix that, we can do temporary abatements of alimony, and there's some other ways around it, but just recognize that if we're just having a down and we're just having a blip, that might not be enough to modify your alimony. Definitely something you'd want to call and talk to us about.